Hello, John Shaffery here today with Brian Koegle from the law firm of Poole, Shaffery & Koegle to talk about California employment law. Brian, what would you say are some of the best practices you are recommending to California employers in 2021?
Compliance for small and mid-sized businesses in California has always been a difficult process. It's a situation where the law is stacked against the employer more times than not. So making sure that you've got somebody in your corner, whether it's a quality HR representative or legal counsel who is adept and understanding in California employment law, is absolutely essential and should be part of your everyday practices as a business owner. But some of the areas where every business can improve. First, making sure you're conducting an annual evaluation of all written policies, procedures, handbooks. If you have an employee handbook, you should be sitting down with your HR professional every single year, making sure that all of the new, updated language as required by California law has been implemented into those policies. And then you reissue the handbook to all of your employees, ensuring that they're signing, acknowledging receipt of the new rules of the road as they move forward in employment in 2021. Second, making sure that you're doing an annual audit of every job description. The job descriptions in California now are almost an essential element of every position that you have in your business. Why is that? The California Fair Pay Act is very specific that you must provide equal pay for substantially similar work. If you don't have job descriptions defining categories, groups of employment, and then the stages, Project Manager 1, Project Manager 2, 3, and 4, based upon experience, based upon education, based upon longevity. A Project Manager 1 may earn substantially less than a Project Manager 4. But if you've grouped them all together as project managers, and you've got only one job description for each of those roles, you are probably running afoul of the California Fair Pay Act. And then the third element is making sure that you're sitting down with every single one of your exempt employees on an annualized basis to go over their job descriptions, to ensure that the exempt duties that they have are actually still their responsibility. It's still what they're doing on a day-to-day basis, that they're not doing more non-exempt duties than they are exempt duties. Why is that? Because as an employee's duties and responsibilities change, the possibility becomes that they are no longer qualified as an exempt employee. And then you would have to revert them back to, put them into a role of an hourly, non-exempt employee. Going over that policy with them every single year as part of your performance review process is a great opportunity to make this a living, breathing document, so that if an employee comes forward years down the line saying that I should have been non-exempt all the time, you can sit down and say, we went over this every single year, and all of your duties matched with what your responsibilities were as an exempt employee. Another one of the key best practices for employers in California is maintaining good documentation, ensuring that personnel files and records are well maintained by your HR professional, office manager, or whoever is in charge of maintaining those records. As part of that record-keeping obligation, we strongly encourage every employer to ensure that they have wage claim release language at the conclusion of every payroll period. What that means is, prior to the time that an employee's hours get submitted for payroll, they should have a chance to review their time and execute a statement that says, in effect, all of the hours reflected above are true and accurate to the best of my recollection. I did not work any unauthorized overtime. I received all of my prescribed meal and rest periods, and I did not sustain any known on-the-job injuries during this last pay period. This piece of information, while it's not definitive, it is wonderful to have that level of ammunition in the event that an employee comes back later on saying that they didn't receive their overtime. They weren't provided meals or rest periods. Those documents support the fact that at the time, they agreed that they were receiving all of their proper benefits.
Now, Brian, as a litigator, when I am called in to represent a client in trial due to improper employment classifications, both I and the employer really need to know what type of exposure we're talking about. What are we?
Well, and on the exemption issues, we could be looking at years, up to 4 years of liability looking back for every misclassified employee. That means failure to pay overtime, failure to provide meal periods and rest periods, failure to provide accurate time and attendance programs and reporting through the payroll system. All of these carry with them substantial penalties, substantial costs of litigation, and then also driving the factor on many of these are the attorney's fees that are recoverable by the plaintiff if they recover even $1 in damages as a result of liability. So John, these cases can get very expensive very fast. You know, the other part about litigation that comes into play here is EPL insurance. Employment practices liability has really become an essential part of every California business owner's toolbox. EPL will cover claims of wrongful termination, discrimination, retaliation in the workplace, and in certain circumstances, they may provide you legal defense for wage and hour violations. I would strongly encourage every California business owner to speak to their insurance broker, their professional that they know in that insurance field, to ask about employment practices liability. It may seem expensive, but quite honestly, it's a lot cheaper than having to hire a litigator to defend your company.
We see the defense costs in these cases, minimum $50,000, upwards of $750 million, and that doesn't even include if there's a settlement or a judgment and an attorney's fees award. Even more the reason why you should stay abreast with the variety of California employment laws. And to seek assistance from one of the lawyers at the law firm of Poole, Shaffery, and Koegle, feel free to sign on to our website at pooleshaffery.com. Thank you for watching.